In the November Roundup, we explore the ATO's approach to the fixed rate deduction when working from home, the clarification on director IDs, but first up, the bill enabling the skills and training and the technology boost is before Parliament. Michael, is the bill what you expected, and what can you tell us about it?
Yes, the bill has been introduced to Parliament and by and large it is pretty much what we expected. You might recall that these measures were announced by the former government back in March. We had an earlier budget this year because of the election. We then weren't quite sure whether the new government or the current government would proceed with these measures until some exposure draft legislation was released a few months ago. The bill that's gone before Parliament looks very similar to what was in the exposure draft legislation. There don't appear to be any material changes. There's a couple of words here and there that are a little bit different, but by and large, the main thrust of those measures remains pretty much what was announced and what we saw in the exposure draft legislation. So in some ways, good that we don't have any major surprises. Look, in terms of key things to remember when it comes to those boosts, first of all, right now, they're not law, so we can't really have 100% confidence, but we're getting close to that. The fact that we've gone through an exposure draft legislation period suggests that it's probably less likely that there'll be any significant changes from here on in. But of course, we do just need to wait and see. We have some kind of pretty active members of Parliament these days. So look, we'll just have to wait and see. Don't want to count your chickens too early. In terms of the skills boost, remember that there is no cap on the amount of expenditure that can qualify for that bonus 20% deduction. And expenditure relating to that measure can potentially qualify up until 30 June 2024. So there is a little bit of time still to run on that measure once the legislation has been introduced and is passed by Parliament. When it comes to the technology boost, it operates in a reasonably similar way, but there are a couple of key differences. Remember that one is subject to an annual cap. It's a $20,000 annual cap basically on that bonus deduction. The other thing to remember is that measure runs for a shorter period of time. Expenditure only up until 30 June 2023 will qualify for that particular bonus deduction. So the skills boost and the technology boost measures, it looks like they are getting closer to becoming law, which would be a good thing for those people who are hoping to take advantage of those bonus deductions and really invest in their people and upskilling their people, and also in terms of investing in technology, digitising their operations, improving efficiency within their operations through digital kind of activities. So it does look like we're making some good progress on this, and we'll of course let you know once that bill has passed through Parliament.
So is there anything else in the bill that we should be aware of and we should be telling our clients?
Yeah, there's quite a few things in that bill that we would want to be aware of because there may well be some clients who are affected. Things to note are, first of all, the government is basically ensuring that digital currencies, cryptocurrencies, will not be treated as a foreign currency for Australian tax purposes unless they've actually been issued by a foreign government, effectively. Now, this change came about because the government of El Salvador basically accepted or adopted Bitcoin as legal tender. And so there then became this issue around, well, should Bitcoin now be treated as a foreign currency, which would have different tax implications? The government said that that's not the intention, but a legislative fix is required to just make sure of that. So the fact that, say, El Salvador accepts that Bitcoin is legal tender when this change passes through Parliament will not make it a foreign currency from a tax point of view. The reason why that's important is because if it was dealt with as a foreign currency, people who make gains and losses on that would generally be dealt with on revenue account. Whereas if it's not foreign currency, we do need to analyse the situation to see whether that asset is held on revenue or capital account, and you could have different tax implications. So that's the first thing that is contained in the bill that's worth noting. The second thing is something that may have reasonably broad application, and that is some relaxation around some of the record-keeping rules for FBT purposes. Now, the FBT system is a little bit odd in some ways, and one of the features of that system is there are quite strict documentation and record-keeping requirements that employers need to satisfy. Basically what this bill is going to do is it will give the Commissioner effectively the power to issue determinations which would provide a relaxation around record-keeping in certain cases. And basically the key idea is that the Commissioner would have the power to basically allow businesses to use their normal business records a little bit more in order to satisfy the FBT record keeping obligations, rather than having to create additional records on top of what they already do. Now, it remains to be seen, of course, exactly what the Commissioner will do with this new power once it's granted, but we would expect that over the coming, say, month, year, whatever it is, that we will start to see some material released by the Commissioner where there are specific relaxation of record-keeping rules around the FBT system, but that bit is still yet to come. The third thing just to be aware of, and only briefly, is the bill contains effectively the framework and the rules for the digital games tax offset. So if you have clients who are involved in making digital games as part of their business activities, this will be something that you do want to get your head around and undertake some analysis to see whether those clients could potentially benefit from that new tax offset, effectively a new incentive within the tax system to provide some tax benefits to those who are involved in the digital gaming industry. I've noticed that the ATO has released some updated materials dealing with a fixed rate for those who are working from home. Can you tell us a little bit more about how this might work in practice?
Yes, quite a relevant area given quite a few people are working from home, even if on a part-time basis. Now, the ATO has released a draft practical compliance guide, that's PCG 2022 D4, which provides a fixed rate deduction of 67 cents per hour for employees and individuals that carry on a business when they work from home. This revised rate does replace much of the ATO's older calculation mechanisms. So prior to 1 July 2022, clients had a choice. They had a choice of 3 methods or a mix of 3 different methods. Clients could have opted to use the all-encompassing shortcut method, which was introduced as a consequence of COVID-19 and provides a deduction of 80 cents per hour for those working from home. Clients could have opted to use the old fixed rate method, which provides a 52 cent per hour deduction, and that rate covers the majority of someone's work from home or home office expenses. Otherwise, the client could have opted to use the actual method, which involved actually calculating the actual portion of running expenses that were deductible or not. When trying to use this method, it can actually be quite difficult to work through how much it costs, for example, in terms of electricity to run a home office. Now, from 1 July 2022 onwards, clients can still use the actual method if they want, but the ATO has now replaced the shortcut 80 cent per hour method and the old fixed rate 52 cent method with a single revised fixed rate of 67 cents per hour. If clients wants to use that revised 67 cent per hour rate, there are just some couple of things just to keep in mind about. The first is that rate encompasses the majority of someone's home office running expenses. So it's going to cover things like telephone costs, electricity costs, internet costs, and mobile phone plan costs. So if the client is using that revised fixed rate, they can't then go and claim an additional deduction for their mobile phone plan. However, this revised rate does not cover home office furniture or home office equipment. So things like tables, laptops, and computers. So if the client has purchased and paid for these assets with their own funds, they could be entitled to claim an additional depreciation deduction for these assets. The revised rate also doesn't cover what we refer to as home occupancy expenses. So things like rent, interest on a mortgage, and home insurance. So depending on the client's circumstances, there may well be scope to claim some additional deductions for at least a portion of these costs. But you do need to be careful because the threshold for claiming home occupancy expenses is far higher, and you do need to work through this in much greater detail. Now, look, there's no getting away that this revised rate method is something that you do need to turn your mind to as a tax practitioner. Many clients will find this revised rate quite relevant because work from home arrangements are just becoming so much more prevalent now. And besides, using the revised rate could be advantageous in the sense that it is far simpler to use. And it avoids some of the complexity of having to to work through the apportionment methodologies for some of the more tricky home office running expenses.
Given that so many people are spending at least some of their time working from home these days, are there any specific conditions that we really need to be aware of and telling our clients about before they start to rely on that new fixed rate method?
That's a good question. The first thing to keep in mind is the client doesn't actually need a dedicated home office to use the revised rate method, but the client does need to be working from home and they do need to perform substantive duties while at home. So occasionally checking the work email while they're home is unlikely to suffice. The second key thing to keep in mind is that the client does need to incur additional running expenses. So if the invoice is in the name of one party, but if you can show that the cost has been shared, for example, in a husband and wife situation where that invoice is being paid out of a joint bank account, that should be sufficient. In that case, both individuals, husband and wife, should be entitled to use that revised rate method as long as the other conditions are met. However, the ATO does make it quite clear now is that if you've got children that are living with their parents and those children are paying board to their parents, that by itself is not sufficient. And in that case, that children or that adult child would not be eligible to use the revised rate, even if they're working from home. Now, the third thing to keep in mind is that whilst this revised rate is intended to make life a bit easier when it comes to claiming work from home deductions, the client does still need to keep records. Records of the expenses, as well as records of how many hours that they've worked from home. Estimates or 4 or 12-week representative periods, unfortunately, are not sufficient. Look, there is a transitional period for the first 6 months where clients can use a representative period, but from then on, the client does need to keep records of how many hours that they've worked from home for the entire period. So in that regard, it'd be prudent to let your clients know that they should be keeping things like timesheets, rosters, or other contemporaneous documents like a diary that shows how many hours they've worked from home if they want to use this method. So in a nutshell, this revised rate can actually make life a bit simpler when you're claiming work from home deductions, but there are some conditions that do need to be met. And to make sure the client is eligible to access these, the main ones are that firstly, the client is performing some substantive work at home. Secondly, the client has incurred some additional running expenses. And thirdly, the client has records of how many hours they've actually spent working from home. Now, the very last thing that I wanted to cover briefly is that this practical compliance guide and this revised rate is still in draft form. So there is a chance that it might change once it's been finalised. But in any case, we'll keep you up to date, when it is finalised in future tax updates.
There's been a lot of confusion on director IDs. The ABRS have stated that they will not take action against directors who have not met the 30th of November deadline, but have applied by 14th of December 2022. And the ATO have released new guidance on who needs a director ID. Michael, what have the ATO released and what's the impact?
Yeah, now what the ATO has released is some draft materials which effectively clarify, but through a legislative instrument modifying how the rules actually work, in terms of how the director ID rules operate for those directors who were previously directors but have resigned before the deadline that applied to them to obtain their director ID. And this is one of the most common questions that we've been getting over the last probably 12 months or so, in terms of people just being a little bit confused about whether they actually need to obtain a director ID or not. Now, by the time you see this, the deadline for many directors to have obtained their ID would have passed. 30 November was the deadline for directors who basically were already directors of a company prior to the rules being introduced. And we're talking back from 4 April 2021 through to kind of the end of October 2021 is where we had kind of this, slightly transitional period. If you were a director of a company from just before the 4th of April 21 up until the end of October 21, then it does appear that technically you would have been required to obtain a director ID. and probably to have obtained that by the 30th of November 2022. Now, the problem was it was very hard to get a clear answer in terms of whether you were actually subject to that requirement or not. We've heard lots of stories from people who've contacted the relevant bodies, government bodies, and were told different things. Depending who you spoke to, you got a different answer. It was very difficult to get any clarity on that. What the Commissioner has released is a draft instrument which basically says that if you were a director of a company, basically during that period from April through to October 2021, but you resign as a director prior to the deadline for you obtaining your director ID, which in many of those cases would be the 30th of November, then you are not required to hold a director ID, and you won't be penalised if you don't have a director ID after that deadline. Now, that is only the case where you have resigned as a director prior to the 30th of November, and you are not a director or eligible officer of a company or other body that's caught under those rules. Now, if you fall within that category, you just obviously need to be aware that if you are going to be appointed as a director later on, then you will need to obtain a director ID, and that will need to be done before you're actually appointed. So you will need to be a little bit proactive about that in future. But there is some relief from, I guess, the potential penalties that could apply for those who are meant to have a director ID at the moment and don't have one. And those penalties can be quite severe. So it will come as a relief to many people who really were just not wanting to get that director ID unless they really had to. It was this issue that was causing quite a lot of confusion and some concern. And so this is welcome news in that it clarifies the position and does provide some relief for those people who are otherwise just left a little bit uncertain about where they stood.
And that's the roundup for this month. If you have graduate or new accountants, upskill them in 2023 with the Tax and Business Services Basics Workshop. It's online in February or in person in Sydney on the 9th of February. See you next round.